Thank you for joining me today on this webinar. I know we're all living through difficult times right now, and estate planning is something that you may have already been thinking about doing. It may have already been on your to-do list. Perhaps it's something you've done in the past, but you need to revisit. But I certainly would say that in times of uncertainty like what we are living through at the moment, it is more important than ever that we have these documents in place. So I just wanted to talk a little bit about that today and what that looks like. So some of the basic issues surrounding estate planning don't change. They remain true whether we're living through a pandemic or it was as it was a few months ago where life was sort of humming along as usual. But as we add COVID-19 to our issues and our day-to-day life, there are some additional complexities that come along with the estate planning process that we have to be aware of. One of those issues is the fact that our courts are slowed down dramatically right now. So depending on what state you are living in, your courts may or may not be either fully operational, operating minimally, or perhaps not at all, depending on what the matter is at hand. Here in New Hampshire, our courts are still open in the sense that we can still file probate matters that would pertain to estate planning. We don't have access necessarily to go into the court, but we can file electronically. Fortunately, New Hampshire did adopt that process in recent years, which is makes things a little bit easier in terms of being able to continue carrying out business. But also we need the probate court if something were to happen to you and we had to apply for a guardianship. So that becomes an issue as well when we're dealing with courts that are likely to be potentially slowed due to staffing issues and related issues due to the virus. So the idea becomes, and the idea always was, to stay out of court. And we're going to talk about that in a little bit more detail in a bit. But I would say that as a result of this situation with the virus, it becomes even more critical than it perhaps was before to try to do what we can to prevent the need from having to go to court at all. The other issue that comes to light during this difficult time is the fact that if medical emergencies should arise, we want to make sure we have somebody in place who can make medical decisions on your behalf quickly and swiftly. We do in New Hampshire have a surrogacy law, which essentially is a law in place that allows someone in a certain order as outlined by statute to make medical decisions on your behalf if you did not have an advance directive in place. However, we don't want to rely on the surrogacy law. There's a variety of reasons for that, but one of them being it's very temporary. So it does not replace the need for an advance directive. What happens is the hospital will allow for you to have someone make a decision under the surrogacy law, but then will essentially immediately instruct the family to move forward with a guardianship proceeding if an advance directive was not in place, because they can't continue to rely on the surrogate in that case to continue making decisions indefinitely. And then the third thing that becomes really important during this crisis, of course, is to make sure that your wishes are in line and well known by your loved ones in advance. So we want to have your affairs in order. We want to make sure that if something should happen, that the right people can step in and take the necessary actions as quickly and easily as we can. So along those lines, there are certain basic documents that we rely upon when it comes to estate planning to address an emergency that should arise while we're alive. And certainly with the virus, it shines a light on the unexpected. So these documents are designed not necessarily for the long-term planning. I want to think about what happens after I'm gone. There's been an emergency. I wasn't expecting this to happen, and I now need someone to be able to step in, take charge and take action. So there are three basic documents, and I would say that this holds true that everyone should have these documents, anyone who is 18 or older. The first document would be a durable power of attorney. So this document is where you name someone who you'll often hear referred to as an agent or an attorney in fact is another word you may sometimes hear. But the point is you're naming someone who can make decisions for you, who can take actions for you with regard to your legal, financial, personal affairs. So for example, you are unexpectedly ill, can no longer manage your own affairs. You still have bills to pay. You probably, still need to have access to funds. Maybe you have a family to support. Maybe you have a business that you're trying to run. If we don't have a power of attorney in place to allow someone to be able to quickly and easily step in and fill that role, the alternative becomes guardianship if you are in fact incapacitated and can't take those actions for yourself. As we touched upon earlier, in a time like this one where we're living in these uncertain times with the court issues we're facing, we don't want to rely on a guardianship if something should arise, nor would we even if the virus were not in place. Guardianships naturally are going to take additional time because we're subject to the court's timeline, and it's also going to come at a greater expense. So if you have a power of attorney in place, there's essentially nothing to be done. In fact, with a power of attorney, these instruments are typically written so that they are effective the day they are signed. So what that means is we're not relying upon a doctor or any third party speaking to whether you have capacity or not. This allows you to present this document. So let's say you were sick and your spouse needed to go down to access a bank account that was only in your name. If they present a durable power of attorney, there's no question as to whether there's been an incapacity or any other requirement has to be met before the bank is going to honor the use of that document. So powers of attorney become very important in an emergency situation, and we recommend, as I mentioned previously, anyone over 18 should have a power of attorney in place. Now, you certainly want to use caution as to who you're naming on the power of attorney because of the fact that you are giving them a significant amount of power over your affairs and your assets. So you want to think about whether the person, of course, is trustworthy, reasonably responsible, responsive. Those are qualities to have in a power of attorney. It used to be that geography was a factor for us as well, having someone who lived close by. With technology being what it is, and we're going to touch on this a little bit later as well, geography is less of a factor. So choose the party that you feel most comfortable with, that you would give this level of control to. If you are able to, and you have another person who you feel equally as comfortable with, I do recommend that you go ahead and name a backup as well. Especially, again, in a time such as this one where we're living through a global pandemic. If you become sick, it is reasonable to be concerned that whoever you name as your agent could become sick as well. So naming a backup becomes all the more important. That being said, you want to use caution with who you're naming, and not just name anyone. So it needs to be someone, of course, that you trust. So the power of attorney is a very important document. Right alongside the power of attorney, we also recommend that everyone have in place advance directives. So if you live in another state, you may have heard this referred to as a healthcare proxy. Essentially, it is the same thing, but it is a document where we are naming someone, and again, an agent, who can make decisions on your behalf with regard to your medical care. Now, unlike the power of attorney, the healthcare proxy is only triggered or activated if you have been deemed incapacitated by your doctor. So this is not like the power of attorney where it's effective the moment it's signed. The advance directive kicks in because you are incapacitated. And the purpose of the advance directive is to, number one, put an agent in charge. So this is the person who becomes your decision maker. And that is why it is so important that you're having these sometimes difficult conversations with your loved ones, but specifically about what kind of care you would want in an end of life situation. So it's really important that they're aware. And so that's why having these difficult conversations is so important. Within the advance directive itself, in New Hampshire, there are certain questions that we proactively initial our choices next to relating to that care. And our job, if you're working with us to put an advance directive in place, we walk you through those questions. But certainly you can also call upon your healthcare provider if you have questions as well, and there's literature that we can provide too. Other states, Massachusetts being one of them, it's more of a broad document where it simply appoints an agent to make decisions for you and doesn't have you make as many sort of choices within the document itself. But it's important with regard to the healthcare proxy that your wishes be known, whether it be in writing within the document itself or verbally communicating with your loved one who's going to be your agent, or ideally both. It's important that those wishes be known for two reasons. The first reason is because we want to make sure you receive the kind of care that you would have wanted to receive had you been able to communicate that wish yourself. That's the first reason. And the second reason is honestly as a sort of comfort measure for your loved one. It is really difficult being the person who is tasked with making a difficult decision regarding end of life care for someone who they love. When it is well known to them what the wishes of their loved one would be, that can make lessen the burden and be very comforting for that person. It can also go a long way towards preserving the relationship between your agent under the healthcare proxy and your other family members. So that is one of our concerns when we're engaging in any type of estate planning, is wanting to be sure that we do what we can to protect and preserve the relationships of the ones that you love when you're not here. Unfortunately, being around these situations as often as we are, we do see families that struggle when a loved one gets sick and often passes away. Having been in these situations many times over many years, we sort of have an awareness as to what are the potential issues that can lead to problems among the family members after you're gone. One of them can be if there's not a lot of awareness about what your wishes would have been, resulting in perhaps one child believing, mom would have wanted X treatment, and the other child believing that mom would not have wanted that treatment. Now, another document that we use as part of these basic documents is designed to get at that root of that issue as well. So in addition to our advance directive, we also have everyone sign what's called a HIPAA release, or a HIPAA patient authorization. This is a separate document that states anyone listed within that document has access to your medical information, can speak with your doctors. If a medical care provider is meeting with the agent under your advance directive, trying to make a difficult decision, when you are unable to make that decision yourself, the parties listed on that HIPAA release can be privy to the conversation. So that can at times go a long way towards making other family members and loved ones feel included and involved in this difficult decision process. When some family members feel shut out from the process, that can breed that kind of discord amongst your family members that we're trying to avoid. The other reason for a HIPAA release, which can be very valuable, is you may not be deemed medically incapacitated, meaning a doctor would state that you can still communicate your wishes. However, with something like the coronavirus or another illness, you may be extremely ill. So it may be very useful to have a HIPAA release in place, which allows a loved one, a spouse, a child, a parent to be able to pick up the phone, call a doctor, get information about a prescription, report as to your condition. When we have this document in place, we eliminate the barriers to that kind of communication that can exist due to the HIPAA confidentiality rules, which are, there for good reason, but there are situations where you would want someone to be able to have access to that kind of information. And so the HIPAA release, working alongside the healthcare proxy and the power of attorney, those three documents are designed to, in an emergency, as I said before, allow for someone to quickly, easily, and efficiently take over, manage your affairs, and help you until you are better and can resume managing your own affairs again. And often those three documents working together can keep us from having to go to court at all for a guardianship proceeding. And as I mentioned before, that's the goal in this situation. So those are our very basic documents. Now, we spend a lot of time every summer in August preparing those three documents for 18-year-olds as they head off to school. And I point that out just to make it very clear that every one of us should have those documents in place at a minimum. And I would also say that it's important with regard to those specific three documents that we keep those current. So you want to refresh those documents, if not every year, then every couple of years. They don't expire per se by their terms, but we can tell you that in practice, the older those documents are, the increased likelihood that we meet some resistance either from a lender, a bank, a hospital, a medical care provider, somebody on the other side who we're asking to honor that document may push back a little if the document is too old. And the reason for that is out of concern that perhaps you had executed a newer one at some point, and they frankly have no way of knowing that that's the case. So to try to reduce the likelihood of meeting that kind of resistance, running into that kind of issue, what we generally tell people is to keep these as up to date as possible. You know, and it's also important as well because as you update these over time, it may call to mind some things that you hadn't thought of, such as, gee, when I first executed this document, my oldest child was the most appropriate person to be the agent. He or she now, you know, works a job overseas and it's just difficult to reach at times. No longer the right choice. I really should update that. Or my wishes have changed, and I really would like my advance directive to now reflect my sort of new beliefs and wishes. So keeping them current helps to ensure that these documents will work when we need them to, and that your wishes are met. So beyond those basic documents, taking this sort of a step further, and this, again, this would pertain whether we were wrestling with this virus right now or not. A common question that we receive from people is, how do I set up my estate plan so that if something happens to me and I were to pass away, things proceed as easily as possible and as efficiently as possible for my loved ones. You know, we hear every day, I don't want to leave my loved ones with a mess. Oftentimes clients come to us because they've been through this process before with a loved one themselves. Perhaps they went through a difficult probate proceeding, or you know, they didn't know where assets were, what the assets were, and it can become a lot of work and a lot of strain on your loved ones during a time when they're grieving. So it becomes sort of this perfect storm of wrestling with the loss of a loved one, in addition to trying to wrap up their affairs, which many people don't realize until they go through this process, how much is involved in that process. It's certainly not as simple as it may seem, you know, or people may think that it should be, especially as between, I would say, husband and wife, or parent and child. There's not always just this automatic transfer of control of assets if you were to pass away. So what happens if you were to pass away and you did not have anything in place, or you didn't have anything in place beyond those basic documents that we talked about before? If you had nothing in place and you had assets in your name that were in your name alone, we are looking at a probate proceeding. So the probate process is a system where the probate court oversees the transfer of ownership of an asset from someone who has died to its new owner, so the beneficiary or the heir. And along the way, there are a lot of hoops we have to jump through and steps we have to take before the court will ultimately, at the end, allow for the transfer of that asset to the new owner. And part of that process is putting creditors on notice to come forward and be able to make claims, or other parties who may claim to be an heir of the estate or beneficiaries. So probate, it takes a long time. We tell people to expect a year. In New Hampshire, in some cases, you may be able to close it out earlier, within 6 months, but in general, you should expect at least a year. We certainly have probates that go a lot longer. It depends on a lot of factors. It depends on what the assets are that we're dealing with, what are some of the unique issues relating to your situation. So for example, if you have real estate and you own real estate in multiple states, right away we can tell you that's going to add to the timeline of your probate process. Whenever you have assets in another state, well, depending on the type of the asset, real estate being a good example, we actually have to open up 2 probate proceedings. So we would open a primary proceeding here in New Hampshire, and then we'd have to open an ancillary proceeding in another state. Now, again, what we spoke about previously, due to the virus, the courts are slower than normal. And in general, even without the virus, courts sometimes are busier than others. Sometimes they're more backed up than others. You know, we have several probates going right now where it's taking a lot longer for us to receive what's called an appointment, giving someone authority as executor to start actually managing the estate administration. It's taking a lot longer than it was, say, back in the fall. And that just happens. It depends on, how many people are sort of in line ahead of you with regard to this process. But especially with the virus, I would anticipate that the courts are going to slow pretty dramatically. Other states may have varying timelines with regard to how long probate will take. But again, the general sort of rule of thumb is expect a year. And that's a long time for your loved ones to be caught up in this process when they're, again, trying to grieve and move on. The other issue is that probate is expensive. Probate, if your loved ones have to hire a lawyer to help them through it, of course, they're going to pay legal fees, but there's also court fees that come along with the process and additional costs that will come up. And the nice part of all of this is to know that probate can be avoided. So we just have to know what to do ahead of time to avoid all of what I had just discussed. So avoiding probate is really done in essentially 3 ways. So the first way would be if you own an asset jointly with someone else and there are survivorship rights. So for example, husband and wife own a home together, husband dies, the wife is going to, assuming they were joint tenants with rights of survivorship on the property, wife is going to take that property, and we won't need a probate situation in order to transfer the asset to her. So joint ownership is one way that we avoid probate. Now, some people will say to us, well, why don't I just add my child or loved one or friend to my deed or to my bank account as a way of avoiding probate? Generally speaking, not a good idea. The reason for that is what happens is that asset becomes an asset of the person you have now added to your deed or to your bank account. So if that person is involved in a lawsuit of any kind, goes through a divorce, goes through a bankruptcy proceeding, gets behind on taxes, the asset is reachable. And so you've now exposed it. There are also tax consequences, which I won't get into in too much detail right now, but there are tax consequences depending on the type of asset. When you simply add someone to your deed or to your bank account, you're essentially making a gift to them. And we've seen this happen. So we had a call a few weeks ago from an accountant that we work with, where his client unfortunately added his child to his deed, and the child got behind on taxes, and the IRS put a lien on the dad's house because on paper that child is a part owner of that house. So we want to avoid that happening. So relying on joint ownership as a means to avoid probate, usually not the best choice. The other way we can avoid probate is through the use of beneficiary designations. So certain types of assets will allow you to name upfront who you want to have that asset if something should happen to you. Good example of this would be a life insurance policy or a 401k, an IRA. If you have any of these assets, you probably recall when setting them up, you filled out a form to name your beneficiary. As long as that beneficiary designation is up to date and has been completed fully, if something should happen to you, that asset will pass automatically without requiring a probate proceeding to your loved one, to whomever the party is that you've named as the beneficiary. Now, I always encourage people, whenever they're sitting down and having this conversation about estate planning, double check those beneficiary designations, because I can't tell you how often we have people tell us that they thought they had the beneficiary set up a certain way. They go and check and they find out it's actually in fact not set up how they thought. So things happen, children are born, marriages happen, and if you never updated your beneficiary designation, it's possible that it's not currently reflecting the way it should be. We've also seen situations where a gentleman was working for an employer, had a 401k, the company switched the provider that was managing their 401k, and for whatever reason, the beneficiary designation didn't carry over. We were very fortunate that he caught that as part of that process, because it can be, unfortunately, quite messy when there is no beneficiary designation in place on an asset like that. So beneficiary designations are a great way to avoid probate, not completely appropriate in every case. So if you have a situation where you have a beneficiary, a person who you want to receive that asset, but they are either too young or perhaps would not do a good job of managing that asset, and you have some concerns about their ability to handle it, then in that case, you may not want to name that individual directly as a beneficiary, and you may instead want to consider using a trust, which is Number three, in terms of the three ways that we generally speaking avoid probate, is the use of a trust. So any asset that's held in trust while you were alive, moved into trust while you were alive, is going to avoid the need for a probate proceeding. So if you have an estate plan in place and you've included within that plan, say a revocable trust, you passed away, your home was in the revocable trust, there's no need to file a probate proceeding if that was, say, the only asset, and then go through the entire probate process before you have the ability to sell or transfer title to that house. When the asset's in trust, right away, you can your loved one can be off and running in terms of administering the trust. So a trust administration in almost all cases is much quicker, it's more efficient, much less expensive, versus going through a probate administration. And it's just frankly easier on your loved ones when your assets are held in trust. So using a trust, there are many reasons to use trust, but one of the most common reasons is to avoid the need of probate administration. And in this time where we're dealing with this coronavirus situation, that becomes all the more important. Now, there are many other benefits of using a trust, of course, as well. It's not simply just to avoid probate. You may also want to use a trust because, as we spoke about previously, you may have minors who are beneficiaries and simply not appropriate for them to inherit assets at a given age. Even if they're not minors, I would argue, having perhaps seen a little too much, but I would argue that even age 21 is very young to inherit assets, even perhaps 25. It often depends on the person who you're leaving these assets to. We certainly have clients who are not comfortable leaving assets outright to their grown children who are in their 40s, 50s. That is not uncommon or unheard of. So using a trust, it's a great tool to be able to leave those assets to be there for the benefit of your loved one, but without giving them full control. So instead, what you do is you appoint a trustee to be in charge of the funds, so that the trustee is making the decisions about when and how distributions take place, as opposed to your loved one who you perhaps weren't comfortable with in terms of their decision-making abilities or maturity, in terms of having full access to those assets. So a trust is a great tool in a situation such as that, to be able to have a little more control over what happens with your assets, as opposed to the control that you would have if you were simply relying upon a will. Now, we didn't touch upon that when we talked about our basic documents previously, but if you don't have a trust, a will becomes important, because that is the document that will say, here is the person who should be in charge of managing my estate. That person is referred to as either an executor or a personal representative, depending on the state you're in. And also, these are the parties who I would like to receive my assets. Now, a will is only effective once it's been submitted to the probate court and the probate court reviews it and accepts it, and then ultimately appoints someone as executor. So by its very nature, a will is involving a probate proceeding. We have clients who come in all the time or who call and say, I'm all set for avoiding probate, I have a will. And they don't fully understand that having a will does not actually keep you out of the probate process at all. Now, if you're using a trust, we still want to have a will, because the will in this case acts as a catch-all for us, just in case there's an asset that was in your name that was not put into your trust while you're alive. So you might wonder, why would that happen if I'm going through the estate planning process? Well, it happens for any number of reasons. You may have an old bank account that you completely forgot about, maybe from college, has $500 in it and just forgot that it existed out there. If you did forget about it and you didn't put it into the trust, the will grabs it and puts it into the trust for you. Similarly, someone may have given you something right before you passed away. You may have bought another property, a piece of real estate, and for whatever reason, did not tell the closing attorney that you wanted to put that property into trust. That would become a probate asset. Your will would grab it and put it into the trust for you. Now, I just had a great question come up. Would transfer on death or payable on death for bank accounts or investment accounts be another way to avoid probate? Yes, they are. It's a great tool. I consider those sort of akin to a beneficiary designation, but absolutely, when we're going through the estate planning process and we're walking through each asset, which is our jobs. So once we decide on a plan or a strategy that's in line with your goals, we then walk through the assets that you have to decide, okay, which assets should go in trust, or if you're not going to use a trust, how can we leverage tools like what's called a TOD or a POD, or beneficiary designation? How can we leverage tools like that to try to either avoid probate entirely or at least minimize it if we can? So transfer on death or payable on death, for certain types of accounts where they're available, they operate just like a beneficiary designation. And yes, they do avoid probate. In some cases, we have the trust actually, or really that's the trustee, but the trust essentially named as the recipient of the TOD or the POD, transfer on death or payable on death. So yes, absolutely, those are important tools, and they are utilized as part of this process. So thank you. That's an excellent question. So in terms of a trust, when you're thinking of a trust, there's really two main types of trust. So revocable versus irrevocable. In a situation like the one we all find ourselves in right now, it's really the revocable trust, perhaps more than the irrevocable trust, that we're focused on right now. A revocable trust, it's easy to use, and I say that because it can be amended at any time. It can be revoked. There's no tax consequences with regard to setting up a revocable trust. So what I mean by that is you create your revocable trust. There's no separate tax ID number that needs to be obtained for that trust. No separate tax filing because you've set up a trust, moved property into the trust, or moved it out of the trust. The trust really sits very quietly in the background while you are alive. And at some point when something down the road, when something should happen to you, either you became incapacitated or you passed away, at that point, we really make use of that trust. So while you're alive and well, you are the trustee of your own trust. So as I said before, you're maintaining full control over everything that happens with that trust. You can move assets inside and outside of that trust as you deem fit. You don't need anyone else's permission to do that. You don't need to be notifying other parties. It's perfectly fine. As I said, you're really owning that asset just as you did in your individual capacity. It's not much different. Once you've passed away, or if you became incapacitated, we would have a successor trustee named within the trust document itself that would then take over. So again, the difference between a trust administration and a probate administration is, with a probate administration, before we have anyone that has any authority to deal with your assets, we have to jump through several hoops, make several filings with the court, and there's a waiting game. With regard to the trust, it's a matter of the successor trustee signing their acceptance. Okay, I'm off and running. And when I say acceptance, it's a one-page document saying I am now the trustee of the trust, and they are off and running. So they can manage whatever assets are in that trust, pay debts if needed, sell assets if needed. So a trust can be very efficient in that regard as opposed to a probate administration. Setting up a revocable trust now is great because you can ensure that your affairs are in order, so that if something were to happen to you, you became unexpectedly sick, you have everything in one place. Your loved ones will have a much easier time of administering your affairs than if they had to go through the probate administration process, as I mentioned. Now, eventually, we are going to come out on the other side of this virus situation, and some of your needs, goals may change over time. And the beauty of this type of trust is it grows with you. So, you may feel one way right now, perhaps based on things like your kids' ages. Right now, not appropriate for them to have full access to those assets, but 5 years from now, you may feel very differently. That could also work in the opposite way as well. You may have adult children who you're very comfortable with inheriting assets right now, but perhaps 5 years from now, maybe there's a marriage that takes place that you're not entirely comfortable with, and you're a bit concerned about your inheritance being exposed in the event of a divorce. That's a reason to amend your trust. And as I said before, easily done. So what you put in place now, you are not locked into keeping this forever, for the duration of your life. These trusts grow with you and adapt to whatever your changing needs and goals are over time. Now, we are in sort of a unique situation here where our normal process with regard to estate planning typically involves an in-person meeting first, where we go into a lot of detail with you about what your goals are, what your assets are, what's the best strategy to accomplish those goals for you. Given the concerns about the virus, we've had to sort of adapt that process a bit. So in terms of what can be done now, the good news is we can still do this. It's not too late. You haven't missed the boat if you haven't done this ahead of time. We can do almost everything virtually up until the signing appointment. So what that means is a consultation can be done just like what we're doing right now with a Zoom conference call. Keep everyone safe, interactive. When we do the Zoom calls with our clients, you're able to just communicate back and forth with us quite easily, and it's really not much different than an in-office meeting. The next step is document drafting and preparation. So that, of course, can be done remotely. We would normally then schedule a meeting where we have you come in and we walk through those documents together in our office. Again, due to the concerns over the virus, what we are doing to sort of adapt our practice is sending those drafts electronically. We have a safe client portal where we can transmit documents back and forth with our clients. So we transmit your drafts to you, and then we would do the same thing we're doing right now. We would do a Zoom video conference call to go through each of those documents in great detail for you. Once we reach the point that you're comfortable with the documents, there are no further changes that you want, we can then schedule your signing. So as of right now, signings for certain estate planning documents will have to be done in person because of a witness requirement and a notary requirement. So our governor in New Hampshire, and I'm told that Massachusetts is on the same path, but I don't know that it's come down yet. But right now, New Hampshire's governor has issued an executive order allowing temporary electronic notarizations. So this just came down, so there's still some things to be worked out. But essentially what they're saying is that we could notarize a document through something like what we're using right now with a Zoom call. So you could sign your document, we've witnessed it, we've notarized it, you would transmit the document to us and we would stamp it. With estate planning documents, certain documents, the will being a perfect example, require 2 witnesses. And under current case law, which could be argued, but most of us are falling on the side of believing this to be the case, under current case law, those witnesses need to be physically in the room with you at the time of the signing. So they have to sign in the presence of each other as well as in the presence of you as the person who's creating the document. So with the virus concerns, for some clients that can pose an issue. We essentially feel that leaves us with 2 options right now. One option is we will still offer signings, as long as things, stay the way at least they are right now. We are comfortable offering signings in our office. So what happens is we've done 95% of the work with regard to the plan. You're coming in just for the signing. We have a separate entrance and an exit for clients only. We have limited staff that are allowed in the office. We only have 2 staff members in our office at a time. We sanitize after every meeting, after every signing appointment. We practice appropriate distancing, so the witnesses are in the room, but they're as far away from you as possible. We have gloves when we're moving documents back and forth. So we're really, doing everything we can to minimize any risk of any exposure for either our clients or our staff as well. And ideally, the process should be short because we'll have done everything else electronically. If you're not comfortable or not well and not able to come in, what we can do is execute most of the documents, the will being a good example of it as an exception, electronically using the new executive order for electronic notaries. So what that would mean is we would really focus on using a trust as opposed to relying on a will if there's any concern about probate avoidance. So meaning you would put together a trust, which actually under New Hampshire law does not require 2 witnesses, so we can notarize the trust for you. We would take extra care to make sure that your assets are in the trust. And then once virus concerns sort of subside, we can have you come back in and sign that backup will. That's, as I said before, it's really just there if you have a trust plan, your will's, the intention is to never use that will anyway. The intention is for the will to just be a safety net in case there's an asset that came into your possession later that you never put in your trust. But the idea would be that you could do the will later, but you could have essentially your entire estate plan set up. So the good news is we are still permitted right now to operate as an essential service in both New Hampshire and Massachusetts, which is good because you know, we do have clients who, because of the virus, are very concerned and want to make sure that their affairs are in order. And so we want to be able to provide that service. And we feel comfortable that right now we have the appropriate procedures in place that we can do this safely. So that would be sort of the overview of some of the primary concerns that I would say most clients are facing right now in light of the virus. That being said, everyone's situation is unique. You know, if you're a small business owner, for example, you may have unique questions surrounding that aspect of your planning. We are happy to speak either by phone or video conference at any time to go over any questions that you might have. And to try to help give you some peace of mind by having these documents in place. Does anyone have any other questions? You can type it right into the Q&A box, or if you prefer, we can also speak privately, but the others can't see your questions when they come up. So feel free to type in any questions that you may have. So I think we've covered. Oh, okay. In terms of how long does the process take? So again, we're operating in unique conditions right now. Typically the way the process would work is that once we've had our consultation, you've decided upon a strategy, we try to schedule your draft review meeting for 2 weeks out from when we've decided to move forward. Given the virus, some clients need sort of an expedited timeline, and we are able to accommodate that. So if you know someone has health concerns and wants to do this quickly, certainly we can do it much quicker. The actual timeline can depend a little bit upon how quickly you're able to make decisions on the client side in terms of who they want to appoint as, say, a backup agent on their healthcare documents. But otherwise, I would say, generally speaking, certainly a two-week time frame is sufficient. But if a shorter timeline is needed, we definitely can address that on a case-by-case basis. I just had another question come in. Will assets transferred by trust, beneficiary designation, or transfers on death also avoid federal and state estate taxes? Great question. So not knowing what state you are in, but I will assume it's New Hampshire. What are New Hampshire's estate tax limits? Okay, so I have good news today, which is that New Hampshire actually doesn't have an estate tax right now, which is fantastic for us as residents of New Hampshire, because if we lived in Massachusetts, well, Massachusetts is a wonderful state as well, they do have an estate tax, just to give you sort of some comparison, and it kicks in at a fairly low threshold. It kicks in at $1 million. May sound like a lot of money, but if you own a home in the Northeast, if you have a life insurance policy, there's a good chance you're at or near that threshold if you live in Massachusetts. New Hampshire, I believe it was in 2006, did away with its estate tax. So currently we do not have one on the state level. Now that could change. I don't know that it will change, but I have to put out there that it potentially could down the road. Federally, the threshold is so high before most people have an estate tax. I mean, you have to have more than $11 million before individually you'd have an estate tax issue. And if you're married, you get to combine with your spouse. So we're talking, over $22 million per couple before you even have to worry about an estate tax issue. So for a lot of our clients in New Hampshire, estate tax planning is not as much of a concern, at least right now. Again, with the federal system, that could change. In fact, it's probably more likely than not it will change at some point. We just don't know which direction it will go. But right now, state taxes is not typically a concern. I will say, to answer your question, however, if you did have an estate tax issue, A beneficiary designation and a transfer on death is not going to help with regard to any estate tax planning. What that's going to do is avoid a probate issue, but it's not going to minimize taxes. If you are exposed to estate tax and you're trying to minimize it, and you're a married couple, the most common tool we use is something called credit shelter trust. So it's a special type of trust designed to capture additional savings with regard to estate taxes. That's a great tool to try to minimize estate taxes using your trust. If you're not married, there are other tools we can use as well. We can look at gifting strategies to try to drive down the overall size of your estate, and other options based upon, this is very individualized and unique. It really depends on what your specific facts and circumstances are. But to answer your question, assets transferred by trust, if it's a certain type of trust, yes, it can be used to avoid federal and state estate taxes. Beneficiary designations and TODs, no, on their own, I wouldn't say they avoid estate tax. I suppose actually, now that I've answered that, in a roundabout way, with a married couple, there is a way you can use a beneficiary designation to potentially overall reduce estate taxes by skipping a spouse. But that gets into sort of a complex conversation that depends on, again, very specific facts and circumstances. So I hopefully that answered your question with regard to estate taxes. Taxes in general, when we're talking about estate planning right now under our current system here in New Hampshire, often we're actually looking more at a capital gains tax issue than we are looking at an estate tax issue. So what I mean by that is when we're having clients who are potentially trying to shift assets out of their own name, whether that be for long-term care planning purposes or other reasons, a tax consideration that has to come into play is the fact that if you give an asset like real estate to someone else, they lose what's called a step up in basis on that asset, which would then potentially expose them to a great deal of capital gains tax down the road when that property is sold. So to just sort of really summarize that, basically the way it works is if you inherit, I'm going to use real estate because it's an easier example. If you inherit real estate from someone, whether it's through a will or a revocable trust, you get something called a step up in basis on the asset. So mom and dad bought a home many years ago. They paid $100,000 for it. Today it's worth $500,000, but you inherit it. After they're gone, you decide to sell it. Your basis in the property is whatever it was worth when they died. And often that can just be tied to the sale price, depending on when you sell the home after they pass away. What that does is eliminate any capital gains exposure. So there wouldn't be any capital gains tax. Versus same facts and scenarios, mom and dad just give you the home before they pass away. You take their basis in the property. So when you went to later sell it, you would have a significant capital gains tax exposure, presumably. So that's usually often the tax conversation we're having when we're in New Hampshire, if we're not talking about federal or state estate taxes. Okay. All right. So, okay. So in terms of if you wanted to move forward with putting planning in place, so we just talked about how we've sort of what can still be done given the virus concerns, and also how it's changed our process a bit. Really, it would be a matter of just reaching out to us, letting us know that you'd like to schedule a consultation. And so again, we can do our consultation virtually, exactly as we are right now with a Zoom video call. I typically tell people to plan for about an hour for that meeting. We're going to go into a lot of detail, and before the meeting we send out a data form where we ask you to complete certain basic information about yourself, your family members, and your assets. And the reason why we ask for that information is so that we can come up with a specific strategy to help you either avoid probate or have the most efficient estate administration administration we can for you. So using that information and meeting with you in person, we'll come up with a strategy. And then if you decided that you wanted to move forward, under the bar rules in New Hampshire, we have an engagement letter that has to be signed where you officially hire us. And then we're off and running in terms of drafting. And as we mentioned before, the draft review meeting can now be done virtually as well, so that you really do minimize any potential for exposure, and we can keep everybody safe. Okay, great. Well, I would like to thank you all for attending. This has been wonderful. If you have any questions, please don't hesitate to reach out. We are going to send out some basic information through email, just kind of an overview of some of the basic documents related to estate planning. But if you have any questions at any time, we always encourage phone calls, emails. We're happy to connect. So I hope everyone is staying well. Be safe and healthy. Thank you very much.